The wind coming off Boston Harbor was sharp that morning, cutting through coats and camera cables with equal precision. Reporters stood in clusters at the front steps of the John Joseph Moakley Courthouse, adjusting their earpieces and brushing hair from their faces as the clouds pulled back to reveal a sun that felt far more ceremonial than warm. Inside, tension built like a rising tide. The federal courthouse, usually a place of quiet deliberation, had transformed into something resembling a high-stakes stage, the kind where everyone's lines had been rehearsed, but no one knew how the play would end. Protesters flanked both sides of the courthouse steps. On the left, signs reading, "Protect State Rights" and "Stop Federal Tyranny." On the right, banners with "Justice Needs Leadership" and "No More Red Tape." The sidewalk between them was a gauntlet of slogans and shouting, with only a few bewildered tourists trying to cut through with coffees in hand. Danielle Freeman walked through the metal detectors with little fanfare. No flashing cameras followed her in. No reporters shouted questions in her direction. She was just another figure in a gray coat, clutching a brown leather folder. But if anyone had looked a little closer, they might have noticed the way her hand gripped that folder, tight and intentional, as if it contained something more than just printed paper. Courtroom 3A was packed. Not in the way it gets for typical high-profile cases. This was different. There were constitutional law professors sitting in the gallery, students from nearby universities scribbling notes, political aides whispering into each other's ears, and federal clerks watching every movement from the benches in the back. Judge Valerie Monroe entered at precisely 9 a.m., her black robes flowing like a curtain before a performance. She settled into her seat at the bench, expression neutral, but her reputation had preceded her. She was known in legal circles for her exacting standards, strict interpretations, and very little tolerance for spectacle. Fair, but never soft. It was said that even seasoned lawyers rehearsed in front of mirrors before arguing in her court. As Judge Monroe called the session to order, Danielle took a seat at the far end of the witness table. She placed her folder on the wood, aligning it with the edge like a ritual. Her eyes scanned the room, not nervously but calculating. She recognized a few faces, a former professor from her law school days, a reporter she once debated on live television, and a DOJ attorney who had laughed too hard during a hearing 2 years ago. None of them looked her way. Not really. On the other side of the courtroom, Robert Langston stood tall, his 3-piece Navy suit immaculate, tie subtly patriotic. He smiled as he unpacked his briefcase, laying out his notes in a fan shape. This wasn't just a hearing for him. It was a show, and he was the headliner. With 12 federal cases under his belt and a winning record few could match, Langston had become the go-to man for defending executive authority. To his right, a staffer set up digital displays and charts. They flashed numbers, headlines, economic forecasts, and Supreme Court quotes, all formatted in the kind of clean graphics designed to sway even skeptical judges. Robert didn't look over. He didn't have to. His show was already set. Danielle's chair creaked slightly as she leaned forward. From across the room, Judge Monroe glanced her way briefly before returning to her notes. The judge's voice rang clear and direct. This court will now hear oral arguments in the matter of Executive Order 40823. A ripple passed through the room. This order, issued under the claim of national economic security, Monroe continued, has raised significant constitutional questions about federal authority and state autonomy. This court intends to hear arguments from both sides, with clarity, brevity, and respect. Danielle watched Langston step to the podium. His tone was confident but not arrogant. He began with history, invoking President Roosevelt, wartime powers, and the Great Depression. He painted a picture of executive necessity, of swift federal response in times of uncertainty. He cited case law, quoted former justices, even referenced bipartisan reports supporting centralized economic policy. The judge nodded slightly. She wasn't agreeing, but she was engaged. Danielle glanced at the wall clock. She already knew how long Langston's opening would last. What mattered more was what came after. A few seats down, Emily Chen, a seasoned constitutional attorney with a calm voice and sharp mind, readied her notes. She would challenge Langston later. Danielle respected her, but Emily didn't have what Danielle had. Not today. As the morning wore on, the courtroom's energy ebbed and flowed with each argument. Langston's team presented, Emily rebutted, and the judge interjected only when necessary. Then came the part Danielle had expected, but dreaded. As Judge Monroe flipped to a fresh page in her binder, her tone shifted slightly. We have a scheduled statement from Representative Freeman regarding legislative intent. However, given the clarity of the arguments so far, this court questions whether additional testimony will be necessary. Murmurs swept the room. Danielle didn't move. She didn't blink. Judge Monroe turned toward her. Representative Freeman, per the rules set forth prior to today's hearing, your time has been limited to 10 minutes, with no supplemental materials permitted for consideration outside of prior filings. Still, Danielle remained seated. The judge continued. The court expects factual clarity, not political rhetoric. It wasn't a slap, but it landed like one. Several people in the gallery exchanged glances. A few eyebrows rose. Danielle finally stood, not abruptly, not defiantly, just purposefully. Your Honor, she said, her voice even, but with just enough edge to command attention. With all due respect, I believe my statement and the materials I've brought are not only relevant, but essential. There was a pause, long enough to feel permanent. Judge Monroe set her pen down. This is a court of law, Representative Freeman, she said, her voice still cool. And while we respect the legislative branch, we do not allow campaign theater. Danielle's hand slowly rested on the brown leather folder. I'm not here to perform, she said quietly, but clearly. I'm here to provide facts, facts that have not yet been presented to this court. Now the silence was absolute. Even Langston looked up. Proceed, Judge Monroe said at last, tone clipped. Danielle opened the folder, revealing a stack of documents, some clearly worn with age, others marked with archival stickers. Her fingers paused briefly on the first page. She looked up, straight at the judge, not confrontationally, but steadily. This folder, she said, contains congressional transcripts from 1947, committee records, and personal correspondence related to the National Security Act. Specifically, Section 2115, which the government's case hinges upon. Judge Monroe's eyes narrowed slightly. They include amendments that were proposed and rejected by Congress. Rejected for the very reasons this court is considering today. Gasps, small but audible, rose from the gallery. Danielle continued, Your Honor, I ask not for your sympathy, only for your time. Because within these pages lies the intent of lawmakers, men and women who considered, debated, and ultimately denied the authority now being claimed. A pen dropped in the second row. Judge Monroe leaned back, silent, watching. Danielle took a slow breath. Her heart was pounding, but no one could tell. She had the floor, and for the first time all morning, the courtroom was truly listening. Robert Langston stepped up to the podium as if it had been built just for him. Tall, silver-templed, and calm in the way only men with decades of courtroom dominance could be, he placed his notes gently on the lectern, then looked around the packed room with the composure of someone who'd argued before tougher judges and intenser climates. And yet, he knew this moment mattered, more than most. Behind him, a screen flickered to life, displaying a well-designed timeline stretching from President George Washington to President Truman, then forward again to the current administration. Graphics faded smoothly between historical crises, economic indicators, and Supreme Court rulings. The room dimmed just slightly, not theatrically, but enough to set the tone. Langston took a breath and began. For as long as this republic has existed, he said, the strength of the executive branch has rested not in force, but in foresight. No one interrupted. The words rang out clean, practiced, heavy with the confidence of centuries of precedent behind them. He spoke of Lincoln during wartime, of FDR confronting depression and disaster. He cited Section 3 of the Constitution, quoting, "He shall take care that the laws be faithfully executed." Then he turned to the present. "The executive order in question," he said, gesturing toward a summarized bullet list on the screen, "was not crafted recklessly. It is a direct response to a fragmented economic structure that endangers not just efficiency, but national security." He paused. "State-by-state patchworks," he continued, "may have served us in the 19th century, but we live in an era of global economic warfare, not horse-drawn commerce." There were nods in the back row, some real agreement, some just impressed with the delivery. Langston turned the page in his notes and continued seamlessly into case law. Youngstown Sheet and Tube, Curtis Wright, Gonzales Verti-Reich. He wove them together like a skilled conductor. Every citation was accurate, every metaphor tailored for Judge Monroe's courtroom style. Intellectual, sharp, no fluff. Judge Monroe scribbled notes. Occasionally, she asked a question, always pointed but never hostile. She was clearly engaged. The courtroom leaned forward as Langston introduced graphs showing GDP loss from regulatory conflict between states. His team even included a chart predicting employment gains if the order held. It was a masterclass in federal authority. Everything looked polished, well-researched, irrefutable. But Danielle Freeman didn't look impressed. Not yet. From her corner of the courtroom, she watched Langston the way a chess player studies an opponent who favors big openings and flashy traps. She made no notes. She had seen enough slideshows and policy papers in her time as a civil rights attorney to know when a presentation substituted confidence for caution. Langston wrapped up with a line she had anticipated word for word. "To govern effectively, we must govern efficiently. And sometimes that means placing national coordination above local delay." He stepped away from the podium, nodded toward the judge, and sat down. Silence. Judge Monroe looked toward the other side. "Miss Chen," she said. Emily Chen stood, quietly, even humbly. She wasn't one for grand gestures. Her hair was tied back in a simple bun. Her navy blazer didn't carry the tailoring Langston's did, but she didn't need it. She had something else, a voice that cut cleanly through the room, soft but certain. "The issue before this court," she began, "is not whether national economic security is important, but whether it justifies rewriting the Constitution through executive order." That got the room's attention. She walked to the podium, her stack of handwritten notes far less glamorous than Langston's digital display. "Let's remember," she said, "that the Constitution created limits for a reason. Even during war, even during crisis, those limits protected the balance of power." She brought up United States v. Lopez, NFIB v. Sebelius, and other modern decisions that signaled the court's retreat from unlimited federal authority. She reminded Judge Monroe of the danger of letting necessity become a blank check. "The founders didn't fear slow governance," she said. "They feared unchecked power." For a while, it looked like the courtroom was starting to tilt. But then, Judge Monroe began to speak. "Counselor," she interrupted during one of Chen's points about the Commerce Clause, "are you suggesting this court ignore 2 decades of post-9/11 jurisprudence regarding executive flexibility during national threats?" Chen paused. "No, Your Honor," she said carefully. "But I am suggesting that economic coordination, while important, is not equivalent to national defense under the Constitution." The judge arched an eyebrow. "Then I suppose you're making the argument that the framers foresaw globalization in its current form?" A few chuckles from the government side. Chen didn't flinch. "No, Your Honor. But they foresaw power, how it could be used and misused." The exchanges grew more frequent, the judge's questions sharper, and somewhere along the way the mood shifted. People started to murmur, some turned toward Langston again. The media folks began updating headlines in real time. Danielle remained still. She watched as Emily, despite her precision, was steadily pushed to the margins of the conversation. She knew what it felt like. It was the sound of a courtroom narrowing, of options closing in. And then Judge Monroe turned toward her. "Representative Freeman," she said, tone brisk, "as per the schedule, your testimony on legislative intent is up next. But frankly, the court finds itself questioning its necessity." Danielle straightened. "Given the weight of precedent already discussed," the judge continued, "and the clarity of the government's rationale—" "Your Honor," Danielle said, rising slowly, "if I may—" Monroe's expression shifted, if only slightly. "With all due respect," Danielle said, "I believe the court is in danger of ruling based on interpretations divorced from their original legislative context. I ask only for the time already allotted." The judge's eyes narrowed. "This is not a platform for political commentary." Danielle's voice didn't rise. "And I do not intend to deliver one." A beat of silence passed. Monroe glanced at the clerk, then back at Danielle. "You'll have 10 minutes," she said, "and no exhibits not previously entered into record." Danielle nodded, her face unreadable. She didn't look to the gallery or seek affirmation. She simply sat, calmly resting her hand atop the folder that had remained untouched the entire morning. From across the room, Langston looked toward her for the first time, really looked, not with curiosity, but with calculation. His expression tightened just slightly. The tide had not turned yet, but something was shifting beneath the surface. Danielle knew the rules. She had read them twice. And she had also read what others had overlooked. Amendments buried in dusty archives, handwritten notes in margins, and letters written between men in power who had never expected a black woman decades later to uncover their quiet truths. In the silence of the courtroom, a different kind of pressure was building now, and Danielle Freeman was ready. The moment Danielle Freeman opened her folder, even the soft, rhythmic tapping of the stenographer's keys came to a stop. Inside the courtroom, time seemed to pause, not in the dramatic, cinematic sense, but in the very real stillness of minds recalibrating. No one had expected her to actually challenge the boundaries set by Judge Monroe, and certainly not with a folder that looked like it had been handled by a dozen archivists and survived a flood. Danielle walked slowly toward the podium. Her steps were measured, deliberate, as if each one peeled away another layer of expectation. She didn't carry herself like a politician angling for applause. She moved like a woman with something to prove, and something to protect. Judge Monroe raised an eyebrow. "Congresswoman Freeman, I trust this will be relevant." "I trust it will be too, Your Honor," Danielle replied. She didn't smile. She didn't blink. She simply laid the folder on the lectern, opened it, and took out the first document. "What I have here," she began, "are congressional records from 1947 during the debates over the National Security Act, specifically related to Section 2115, which the executive order cites as precedent." In the second row, a law student's pen froze mid-sentence. Danielle continued, "These aren't just the final versions. These are the committee reports, floor debates, handwritten amendments, even correspondence between legislators." Judge Monroe leaned forward slightly, just enough to suggest interest. Robert Langston sat straighter, flipping through his own notes, searching for something, anything, that anticipated what Danielle was now unfolding. "Let's start with Amendment 47, she said, holding up a yellow document protected in a clear sleeve. Proposed by Senator Robert Taft, this amendment would have given the President the exact kind of sweeping authority that the current executive order now claims. Danielle paused, letting the words sink in. The amendment was debated for 3 days, she said. It was ultimately rejected, not quietly, not procedurally, but vocally and deliberately, because even in 1947, Congress recognized that economic flexibility does not justify unchecked executive authority. Langston's pen stopped moving. Danielle laid the document down and moved to the next. Here, she said, are personal letters between Senator Taft and President Truman. In one of them, dated October 11, 1947, President Truman explicitly states, and I quote, Authority in matters of domestic policy must remain in legislative hands unless otherwise declared by statute. The room murmured. Reporters scrambled to tweet, write, record, anything. Judge Monroe held up a hand. "Silence, please." She turned back to Danielle. "These documents are not part of the official record." Danielle nodded. "Correct, because when I requested time to submit supplementary materials, the court denied it. But I brought them anyway, because I knew once they were seen, they couldn't be unseen." Monroe's gaze held hers. Danielle opened the last section of the folder. "And finally," she said, "I present a Department of Justice memorandum dated 6 months ago from the Office of Legal Counsel. In it, DOJ attorneys clearly express concerns about the constitutionality of any executive order attempting to override state law and economic regulation without explicit congressional authorization." She held up the memo. It was marked as a preliminary internal opinion, but the content is clear. Langston stood abruptly. "Your Honor, that memorandum was not part of discovery. It's not a final position." "I agree," Danielle interrupted, without turning. "It wasn't disclosed, and yet here it is, undermining the very argument your team has built this case upon." Judge Monroe's eyes narrowed. "Mr. Langston," she said, turning slowly, "why was this memo not disclosed?" Langston hesitated. "We did not believe it constituted formal legal advice." "But it exists," Monroe said, "and it directly conflicts with your presentation." Langston opened his mouth, then closed it again. Danielle didn't move. She could feel the shift in the room, not applause, not celebration, but respect, something quiet and solid. Judge Monroe closed the folder on the bench, fingers tapping lightly against the edge. "These documents," she said slowly, "are significant." She looked at Danielle again. "Why bring them now?" Danielle's voice softened, just slightly. "Because I believe history matters. Because we don't govern by memory, we govern by record. And because I was told explicitly that my presence here was unnecessary, that legislative intent could be inferred. But it can't be. It must be heard, even if it comes from someone the room wasn't expecting." Silence. Not a hostile one, but reverent. Judge Monroe leaned back in her chair. "This court will recess for 15 minutes. As she rose, murmurs returned. Reporters burst out of the room. Phones lit up. Students whispered furiously. Danielle simply gathered her folder, closed it carefully, and walked back to her seat. Langston didn't look at her. Emily Chen did. She mouthed a quiet, stunned, "Thank you." Danielle offered only the smallest nod. Outside, the buzz had already begun. Freeman files trended online before the judge even returned to the bench. Legal analysts on cable news were scrambling to interpret what just happened, but inside, Danielle sat calmly. This wasn't a performance, it was accountability. When the court resumed, Judge Monroe's tone had changed. Gone was the clipped precision. Now it was slower, more careful. After reviewing the materials presented by Congresswoman Freeman, she began, "This court finds that substantial constitutional questions remain unanswered regarding the legal basis for Executive Order 40823. Langston sat motionless. "The court is particularly concerned about the apparent failure to disclose a memorandum from the Department of Justice," Monroe continued, "and we will be expecting a full explanation from the government at the conclusion of today's hearing." Danielle felt no triumph, just clarity. "The request for a preliminary injunction will be reviewed with these materials in consideration," Monroe said, "and until that review is complete, Executive Order 40823 is hereby suspended." Gasps, audible ones this time. Danielle didn't flinch. Langston shifted in his chair. His notes no longer mattered. Judge Monroe closed her binder. "This court is adjourned for the day." The gavel hit the wood, sharp, final, undeniable. Danielle stood. She didn't rush. She didn't raise a fist or take a bow. She simply picked up her folder and turned toward the exit. As she reached the door, a voice called out, "Ms. Freeman?" She turned. A young law student, 20-something, glasses slipping down his nose, stood awkwardly in the aisle. "That was kind of amazing," he said, almost embarrassed. Danielle smiled for the first time all day. "Dig deep," she said gently. "That's where the good stuff is." When the courtroom reconvened after recess, something had changed, and everyone could feel it. The lights hadn't dimmed, the chairs hadn't moved, but the air? It was different. Lighter in one sense, heavier in another. Even the security guards near the doors stood a little taller, as if the shape of authority had shifted during those 15 minutes. Judge Valerie Monroe re-entered, her expression unreadable, but her eyes? Focused. Sharper than they had been all morning. She no longer looked like a woman defending the structure of her courtroom. She looked like someone grappling with a truth too solid to ignore. Danielle Freeman sat calmly at the witness table, her hands folded on top of the now closed brown folder. She didn't look toward the gallery, didn't exchange glances with reporters or allies. She simply watched the bench, the way a pianist watches the keys before returning to the melody. The murmur of the room hushed as the clerk tapped her gavel gently. Judge Monroe cleared her throat. "Before we proceed with closing arguments," she said, "this court would like to acknowledge the new evidence introduced by Congresswoman Freeman earlier today." She turned slightly toward Danielle. "This evidence, while not part of the initial discovery, carries substantial historical and legal weight." The gallery was stone silent. "Particularly concerning," Monroe continued, "is the 2024 memorandum from the Department of Justice's Office of Legal Counsel. The court finds that its content directly challenges the arguments presented by the government." Robert Langston's jaw tightened, but he didn't speak. Judge Monroe looked toward him. "Mr. Langston," she said, "this court will require a written explanation, submitted within 48 hours, detailing why the memorandum was not disclosed during discovery proceedings." Langston nodded once, slowly. The judge returned her gaze to the courtroom at large. "Furthermore," she said, "the materials provided by Congresswoman Freeman, especially the 1947 congressional records and related correspondence, raise serious constitutional questions regarding the scope of executive power as outlined in the National Security Act." Danielle didn't blink. She had rehearsed this moment, not for applause, but for impact. Monroe continued, "The court acknowledges that legislative intent plays a crucial role in interpreting constitutional authority, particularly when historical precedent is being used to justify modern executive action." Now she looked directly at Danielle. "Congresswoman Freeman, this court thanks you for your diligence." Danielle gave a small nod. Nothing more. Behind her, reporters were scribbling, typing, whispering into recorders. The gavel hadn't even dropped yet, and the story was already everywhere. Outside the courthouse, camera crews were jockeying for sidewalk space. Headlines had been rewritten. Freeman's folder was now being called the Game Changer. Back inside, Judge Monroe leaned forward. "The motion for a preliminary injunction is hereby granted. Executive Order 40823 will be suspended pending further judicial review." The room stirred. No one cheered, no one dared, but the silence was no longer charged with tension. It was filled with the weight of consequence. Langston sat back, his shoulders stiff. His legal machine, so confident just hours before, now looked like a beautiful car with the engine knocked out. Emily Chen, seated beside Danielle, leaned over just slightly. "You flipped the whole thing," she whispered. Danielle exhaled slowly. "I didn't flip it," she said. "I just uncovered what was always there." When court adjourned, people didn't rush to the exits. They lingered. Law students wanted to study every detail. Reporters waited to see if Danielle would speak. Monroe's clerks moved like chess pieces, quickly gathering materials for review. Danielle stood, took her folder, and headed for the door. This time, every eye in the room followed her. Out in the hall, a young journalist held up a microphone. "Congresswoman Freeman, did you expect this kind of reaction?" She smiled faintly. I expected the truth to matter, that's all. Do you think the order will be permanently struck down? I think courts are at their best when they listen, when they don't rush past context. That's all I ask. She turned to leave, but a voice called from further down the hallway. Danielle! She turned. It was her former professor from law school, Professor Lena Barrett. Stern, brilliant, famously hard to impress. Barrett approached, eyes shining, with something rare. Pride. You did the work, she said simply. Danielle nodded. You taught me how. Barrett chuckled. I taught you where to look. You taught yourself how to see. By the time Danielle exited the courthouse, the sun was breaking through again. Boston Harbor glittered like glass. Protesters were gone, replaced by curious onlookers and media vans. A few feet away, Langston was giving a statement to the press, measured, controlled, spinning the loss as a procedural hiccup. Danielle didn't listen. She had nothing left to prove to him. She walked to the car waiting at the curb. Her staffer opened the door, but paused. They're saying you made history, he said. She glanced back at the courthouse, then down at the folder still in her hand. No, she replied softly. History was already written. I just read it out loud. As she stepped into the car, her phone buzzed, text after text, emails, mentions, media requests. CNN wanted an exclusive. Harvard Law had just announced they'd be adding a lecture series on constitutional research in legislative context, and she was invited to speak. Law students from UCLA, Georgetown, even a tiny school in Montana had sent thank you notes. The hashtag #HatchFreemanFiles was climbing the trending list. She set the phone down, leaned back, and closed her eyes. She wasn't exhausted. She was grounded. Because in a world full of headlines and headlines about headlines, she had done something simple. She had brought the facts, and she had let them speak. No one in the courtroom knew what to expect after the lunch recess, but they knew it wouldn't be the same courtroom they'd entered that morning. The halls outside were abuzz, not with the chaotic energy of scandal, but with the kind of reverent silence you might find in a museum after hours. Conversations were quieter, movements slower, as if everyone was aware they were walking through the early hours of something historic. Danielle Freeman returned to courtroom 3A with the same brown folder tucked beneath her arm. Its edges were a little more worn, its spine slightly frayed from use. It had served its purpose, but it still felt like armor. The press had grown thicker in the hallway, and cameras flashed with every step she took. Someone whispered, "That's her," as she passed. Someone else muttered, "She broke it wide open." Inside, Judge Monroe resumed the bench with a calmness that bordered on solemnity. Her robe no longer looked like a symbol of formality. It looked like the weight of responsibility itself. She scanned the room, let her gaze rest briefly on Danielle, then turned to the bench. "The court," she began, "has spent the last hour reviewing the materials submitted by Congresswoman Freeman, as well as considering the arguments presented earlier today." She paused, not for effect, but to collect the right tone. "It is the opinion of this court," she continued, "that Executive Order 40823 raises substantial constitutional concerns regarding the overreach of executive authority, specifically where it conflicts with legislative intent and previously codified state protections." A collective breath left the room. The memorandum from the Department of Justice, dated February of this year, represents an internal analysis which contradicts the government's current legal argument. While not a formal ruling, it reflects legitimate constitutional doubt, and the court finds it unacceptable that such material was not disclosed during discovery. Robert Langston sat rigid in his chair. His jaw was tight, his hands folded, but there was no visible defiance, only calculation. Damage control mode. Judge Monroe pressed on. The 1947 congressional records, including amendment debates, committee reports, and correspondence between legislative officials, provides substantial evidence that the framers of the National Security Act specifically rejected language authorizing the executive branch to act in the sweeping manner proposed by this order. She adjusted her glasses. This is not a question of efficiency. It is a question of authority, and no president, regardless of motive or party, may create through executive fiat what Congress has repeatedly refused to codify. Danielle felt the words ripple through her, not because they were unexpected, but because they came from someone who had once tried to silence her testimony. There was a kind of poetry in that reversal. Judge Monroe laid her hand on the edge of the bench. Accordingly, this court grants a preliminary injunction against Executive Order 40823. The order is suspended until a full constitutional review is completed. A rustle swept through the gallery, papers shuffling, whispers rising. Reporters immediately left their seats, hurrying toward the hallway to file breaking updates. But Monroe wasn't finished. This court further finds the Department of Justice in potential violation of its disclosure obligations and expects a formal explanation within 48 hours. Should this court determine the omission was intentional, sanctions may be pursued. Langston didn't respond. His shoulders dipped slightly. Judge Monroe looked toward Danielle. Her gaze lingered for a moment, steadier this time. This court recognizes the extraordinary diligence demonstrated by Congresswoman Freeman in compiling and presenting critical legislative history. It serves as a reminder that constitutional interpretation must never drift too far from its original moorings. Then the gavel fell, sharp, simple, final, and just like that, it was done. Danielle stood slowly, clutching the folder as she had all day. She didn't make a statement. She didn't need to. As she walked out of the courtroom, she was greeted not by chants or cheers, but by the respectful nods of law students and scholars who now looked at her the way one looks at a professor, not a politician. One student, probably no older than 20, held out a notepad. "Can I ask something?" Danielle paused. "Sure." "How did you know where to look? For those records?" She smiled, not out of pride, but out of memory. Because when you're told something's irrelevant long enough, it usually means it's hiding something powerful. The student nodded, scribbled quickly, and stepped back. Danielle's staff greeted her with cautious grins. One of them held up a phone. "Ma'am, you're everywhere. CNN, MSNBC, even Fox News is covering it." "I'm sure they all have different headlines," Danielle quipped. "They actually don't. They're all calling it the Freeman reversal." She blinked. "That sounds more like a jazz album than a legal decision." Her aide laughed. "It's trending. Hashtag Freeman reversal is everywhere." Outside, the October sun had fully broken through the clouds. The harbor shimmered again, the air cool and crisp. Across the street, a small crowd had gathered. No signs, no chanting, just watching. Some with their phones up. Some just watching with folded arms and quiet faces. Danielle stopped before stepping into the black car waiting for her. "I want to walk for a minute," she said. Her aide looked hesitant but nodded. She stepped away from the vehicle and began walking slowly down the edge of the courthouse plaza. Each step felt heavier, not from exhaustion, but from the realization that her life had just shifted in a very public, very permanent way. People greeted her softly as she passed. "Thank you, Congresswoman. You gave me hope again. I'm studying law because of today." She nodded politely, warmly, but her thoughts were still in that courtroom. She hadn't set out to embarrass the government. She wasn't chasing clout or headlines. She had simply known that the evidence mattered and that someone needed to bring it to light, especially when it was being ignored. She reached the edge of the plaza, where a group of older citizens stood talking quietly. One woman, wearing a tan coat and a scarf covered in American flag print, stepped forward. "My husband worked for the Congressional Research Service back in the 70s, she said, her voice raspy. "He used to say the worst thing you can do to the Constitution is pretend it only says what you want it to." Danielle smiled gently. "That sounds like a wise man." "He was," the woman said, "and he would have been proud of what you did in there today." Danielle felt her throat tighten. "Thank you," she said softly. As she turned to leave, her phone buzzed again. A message from a Harvard law professor. "We'd like you to deliver the keynote next semester. You've just become required reading." Another from a civil rights organization. "Let's talk scholarships. Your story will inspire the next generation of legal minds." And one from a journalist. "Sources confirm DOJ launching internal review based on memo. More fallout to come." Danielle exhaled. Not because it was over, but because it was just beginning. She looked back toward the courthouse, its tall windows gleaming in the afternoon light, and thought not about her victory, but about all the voices history had buried, and how many more still waited to be heard. 3 weeks after the ruling, Danielle Freeman stood at the edge of a lecture stage at Georgetown Law. The hall was packed, not with politicians or donors, but with students, some in hoodies, others in suits, some taking notes feverishly, others just watching. The kind of quiet you get when people aren't being polite, but present. Behind her, a simple slide read, "Echoes of Justice. Why History Still Speaks." She stepped forward to the podium, no folder this time, just a single sheet of handwritten notes folded in half and tucked into her jacket pocket. "I was told once," she began, "that the most dangerous thing in law isn't bad precedent. It's forgotten precedent." A few nods in the front row. Because when something's forgotten, it stops being part of the conversation. And when it's out of the conversation, it can't defend itself. She paused, letting the silence settle. "That's what happened in my case. Not corruption, not malice, just forgetting. Busy people, important titles, too much noise. And in the noise, we lost track of what Congress said in 1947. We lost track of what the Constitution limits. We lost track of how power is supposed to be shared." She walked slowly, hands clasped loosely in front of her. "I'm not a hero. I'm not even the best lawyer in that courtroom. I just had time, and stubbornness, and maybe a little chip on my shoulder." Laughter bubbled softly across the room. "But what I really had," she continued, "was a reason. Because where I come from, we've seen what happens when no one pushes back. We've seen neighborhoods ignored, families broken up by policy crafted without empathy, courtrooms that don't look you in the eye." Her voice lowered. "So I dug, not because I had a strategy, but because I had a gut feeling that the truth was older than the argument." She looked up again, making eye contact with a student in the back row. "And I found it, not because I'm brilliant, but because it was there, waiting, and no one else bothered to look." The room was still. "That's what law is," she said. "It's not just pages and rulings. It's memory. It's history. It's the stubborn insistence that what we said back then still matters now." She opened her jacket, took out the folded sheet of notes, and placed it on the podium without looking at it. "You're all going to be brilliant," she told them. "You're going to argue cases I'll never understand. But my only ask, my only advice, is this. Don't forget to listen to the documents that no one else is quoting. The dusty ones, the inconvenient ones." She smiled softly. "Because that's where justice echoes. And if you're quiet enough, you might hear it." When she finished, the applause didn't roar. It rose slowly, solid, sustained, like a standing ovation in a church. She stepped down from the stage and was immediately surrounded by students asking questions, not about politics or careers, but about archives, about finding original committee transcripts, about how to request old CRS reports, real questions, rooted in purpose. Later that night, back in her apartment, Danielle made tea, no TV on, no phone in hand, just the warmth of chamomile and the silence of reflection. The folder, now retired, sat on her bookshelf beside a small, handwritten card from one of her law clerks. It read, "Because of you, I believe law can still mean something." She traced the edge of the folder with her finger, a simple manila jacket, worn from use. but inside it held a piece of the Constitution's heartbeat. Her phone buzzed once, a message from her mother. Saw the speech. Your father would be proud. So am I. Love you. Danielle smiled, set the phone down, and whispered aloud to no one in particular. Still listening. Outside, the lights of the Capitol shimmered like stars reflected in water, and somewhere, deep inside the halls of law schools, courtrooms, and congressional archives, the echoes of justice stirred again. In the quiet after the storm, as the courtroom lights dimmed and the news vans rolled away, something lingered, something that didn't make headlines but stayed with the people who truly listened. It wasn't just about laws or legal brilliance. It was about the quiet strength of someone often underestimated, who reminded the world that dignity doesn't need a microphone to be heard. What Danielle Freeman did wasn't loud. It wasn't flashy, but it was deliberate. She stood up, calmly and with care, in a space where many thought her presence was symbolic at best. And by simply telling the truth, armed with history, patience, and a steady moral compass, she didn't just win a case. She realigned the way people looked at the Black community in spaces of power. She challenged the room to see beyond titles, beyond assumptions, and into the heart of what justice really means. You see, in a country where the Black community has so often been talked over or talked about, Danielle's quiet insistence on being heard was a kind of healing, not just for her, but for every person who's ever been told they don't belong in the room. She didn't demand respect. She earned it, and in doing so, gave it back to those watching. Her story teaches us this: hold on to your truth, even when it shakes, even when no one else seems to see it, because sometimes the strongest kind of justice doesn't roar. It whispers through old papers, quiet courage, and the lived wisdom of those who carry both history and hope. And maybe that's the lesson we all carry, especially now, that justice isn't always swift or glamorous. Sometimes it's a woman with a worn folder, standing her ground, and like a quiet lantern in the window, a small, principled act can light the way through some of the darkest corners of public life. So, wherever you are tonight, take a moment. Reflect on the people in your life who've spoken truth when it was hardest. Maybe they were part of the Black community. Maybe they were just someone others had written off. But if this story touched you, consider passing it along. Not because it's viral, but because it's vital. And in that passing, may we remember, the truth has a funny way of rising, especially when we least expect it, and especially from the places we so often overlook.